This was asked just 2 days ago out of Chicago, Illinois. How long does a patent last? 20 years, that's easy. And how do I know if it's a design patent or a utility patent? Okay, great question. So design patents have a design patent filed before May 13th, 2015, have a term of 14 years. That's true. Those that are filed after 2015 have 15 years. So that's true, actually, I clarified. So 20 years is for the utility patents. 15 years is for design patents. That is the truth. So how do you tell? One of the best ways to tell is if there is a letter D for design, right before the number. Also, so if there's not a D and the numbers are like around 10 million, because that's the most recent patents that were being issued now are 10,800,000, then it's a utility patent. There are only about 1 million design patents. I don't think we've actually hit the 1 millionth design patent yet. So that should give you a big clue. What I can do is show you really briefly. Here we go. Here's one that is called Waste Management System Implementing Fuel Tax Monitoring. This was granted last year, September, very recently. This is a utility patent. You can tell right there, there's no D. It says US 10,776,884. And thought we'd mention tax because we're doing tax today. And you get a term of 20 years from the date of filing, not the provisional. See, they've got this additional date of filing. So it's December 3rd, 2018, 20 years from this date will be 2038. Okay, and let's take a look and see if there are any design patents out there. You can go back to your search results. And so a design patent will have the letter D right in front of it. And so you know right away that the protection is not what it does, which is the utility side, but just what it looks like. So the very elegant curvature, the positioning of this USB drive. Can't believe someone's going after this on this day and age. It can find a USB slot in my computer these days. But anyway, very interesting. So that is the design patent. Great question. Thank you for that. Let me jump back to our live to see if we have any follow-up live questions. Yeah, we do have one. It's like from Brian Allentop. The question is, I hear some inventors mention they have multiple patents on their invention. Can you explain why this happens? Wouldn't one utility patent give enough protection? Well, as it turns out, in order to get the broadest rights possible for a patent, for an invention, you almost always want to try to get multiple patents and cover what's called a portfolio. So during examination, several things can come up. When you first file a non-provisional, if your claims are a bit broader than they should be, or we're asking for more than you sort of deserve in a way, the examiner could say, look, you've actually got more than one invention here. And they could say, you've got to pick which invention, right? Either it's the device or the method of using the device is a pretty classic example. And so usually you want to go for the device, right? That's going to be the broadest rights. And so you do an election. I'm going to elect to move forward with the device. So before that parent application on the device gets granted, you want to file what's called a divisional patent application, and they will run in parallel covering the method of use. That's an easy way to sort of build a portfolio through divisionals where you actually have separable inventions. The examiners don't want to conduct a search on both inventions, right? They're not being paid for that. So they're sort of in a way making sure they get paid for each application. Another great way is just before the parent issues is when you get a notice of allowance, right? The big celebration time, the examiner says, yep, this is good to go. This is novel and non-obvious and has utility. We're going to be able to grant this a patent. Before it gets issued, you've got the ability to file a continuation. If the parent issues, right, it gets granted, you no longer are able to file a continuation. And what a continuation is it allows you to take a sort of a second bite at the apple. And let's say you got that device, but during the pendency, right, which could be a year and a half, 2 years sometimes, while it's under examination, you might have come up with a new version, some new improvements or ways that your customers love it, but it wasn't actually included in that original filing. Well, it's a new improvement, right? It's an option or it's a new improvement. So you want to be able to protect that as well. And you can using a continuation or a continuation in part. And that's a child patent, it's called, from the parent, but it must be filed before it gets issued. Otherwise, your original parent filing will act as prior art against you on any similar filed situation. So a little bit complicated on the answer, but thank you for bringing that up, Brian.